Good morning, afternoon, evening. Hello, everybody. I'm going to say hello to everybody who I see out there. I see Mr. StreamYard. I don't know if you guys get that joke, but on my screen I see StreamYard, and that's what I'm doing this on. So when I say Mr. StreamYard, it's a joke. Get it? The 1-1 toe cramp splat Frank Renee, I think from Jamaica. Hello, merci. Angel, Miguel, Donald, Rondale, Jasper, Just Change, Darren. Thank you all, and whoever else joins us and comes on. Wonderful to see you all. Hi, 22 J Dog. Greetings and super cats. I could do this all day, just make the video about just read the names. How about we do that, Gary? Anyway, thanks very much. And welcome to everybody. What I thought I was going to do today, and what I will do is, as briefly as possible, kind of tell you where we are, what we got coming up this week, and then you can go your merry way. Before I start, of course, I have some very marginal jokes for you. I promised marginality, so that's what I intend to deliver. My wife says I have two major flaws. I don't listen, and something else. This is true, by the way. I have an epileptic disorder. It's actually true. Really. I mean, seriously, I actually do, as it turns out. So I have an epileptic disorder, really. And as it turns out, my favorite food is seizure salad. I wouldn't have said that unless I really did have an epileptic disorder. I had a conversation with somebody about this topic yesterday, and ultimately, who really cares about people who are apathetic? And last but not least, I got this new stick deodorant today. I looked at the instructions. They said, remove cap and push up bottom. To be honest, I can barely walk, but when I break wind, the room smells absolutely lovely. Anyway, let's just move on. So there's court dates. Now I'm referring to Gtii, just so we're clear. I'm talking about this week is June 18th. There are various court proceedings, and that is Wednesday, I guess. Today's the 16th, so that would be Wednesday. Those court proceedings take place in Las Vegas. I will, of course, cover it in some fashion. I'll be there, and I'll be able to tell you what's going on. So here we go. So what's that issue, and where are we at today, and what are the issues that we have to get done? So one, audit certification. We discussed this before. The last live stream I did, I referenced that at least the attorneys for the receiver indicated that 3 out of the 5 attorneys had provided whatever they needed to certify the audit, or whatever they required. They filed something with the court. That was about a week ago or so. I have not seen anything since then. I've asked for the Receivers Council that specific question. They have not yet responded. So I don't know if they are in the process of getting it, have gotten it, have not gotten it. I don't know what the court will do if the 2 attorneys have not certified it. So the way it works is, apparently there's an auditor who's preparing an audit, obviously, of Gtii, and apparently the auditor, per their own rules or policies, I don't know if it's required or standard, they require certain parties to certify certain information. This audit came down to, I think the only thing that was required was 5 attorneys to certify certain information. 3 of them have. 2 of them, as of now, don't know that they have, but I don't know if they have not, but there's been no filing that says that. And the auditor previously said required all 5. So I don't know if 2 of those attorneys who have not responded to this point in time, if they don't respond, what the court will do. Will the court order them again? Will the court order some kind of contempt proceeding? I don't know. I don't know if the Receivers Council has spoken to them. And the other part is, I don't know let's assume, for the sake of discussion, that the Receivers Council is not able to get those 2. Could the auditor still go forward with notes, noting that we got 3, but we didn't get 2? My understanding is previously when the 5 certifications, or I'm calling them certifications, it may be a different term for the auditor, but when the 5 were outstanding, the auditor wasn't willing to sign off with the 5. I don't know with 2 or 1 if that will change. I expect that by the 18th, we will know. And obviously the completion of the audit is a necessity to get it to trading again. I know at least I've been informed that it's complete other than those certifications. So that's what we will find out on the 18th. So by the 18th, the attorneys for the receiver will either, by that date, which is Wednesday, they will either report to the court that everybody has responded except for X, and I want to do this to get them to do that, or they might say that everybody's responded now and we've gotten everything we need and we can move on getting the audit certification done and submitted as required. But we will know that by the 18th. So that's Wednesday. And again, if I got a pleading is some kind of court filing. If I had gotten it like I had gotten received from the first time, I would have told you, I would have known myself. And again, I've reached out to Receivers Council. They have not responded. I don't take that any way in particular. Sorry about that. I don't take that any way in particular, but that's what they've elected not to do. Maybe they want to keep it quiet. I don't know. Whatever it is, I will certainly report on it. You will know, and we will find out what's going on. We'll see if they become compliant. That's really the issue. All right. On the 18th, if you recall, the last hearing, which I think was about the 5th of June, the court granted the freeze order. So all the disputed shares, which was about 178 million shares, the court granted the order to freeze those shares so they can't be sold, borrowed against, etc. And that order was entered since our last live stream. So what happens is the court will say the ruling, and then a physical document has to be prepared. In Nevada, I think it requires specific factual findings, so it's a fairly specific document. And then the court will then sign that order, and that actually becomes the order of the court. So the order that the judge gives in court is not the order that becomes the significant thing. It's what he signs and becomes part of the court record. So if you recall that there's about 178 million or so based upon 87 different parties who had disputed shares. If I recall, the Receivers Council indicated they were in contact with many of those parties, and many of them were voluntarily going to, or at least some of them were going to voluntarily return those shares. So what they tried to do, based upon the motion that was set on the 5th or heard on the 5th, was set up a process in which the shares could be tested and the ownership of the shares could be tested. A lot of the parties that attended, and the only ones who attended are the ones who have the significant amount of shares. That would be Mr. Reichman. And he wasn't personally in attendance, his counsel. By the way, it said Reichman is 81 years old, just as a side issue. Reichman, Griffin's counsel, Benintendo, which again is a different Frank. Justine Reichman's counsel, I think, was there. And I think that's it. All the others, so to the extent of those other 87 are not controlled by those 4, they didn't appear. And so a lot of those, to the extent, and there were a lot of ones that I think there's an individual in charge other than Reichman or somebody else. A lot of them will probably roll over and return the shares, but we don't know that number yet. And it's being, I think it will be, we'll get it in drips from reports, etc. But the procedure is being challenged. So they proposed a procedure to determine these disputed shares, whether they are good or not. They gave the court a suggestion. Then they were supposed to meet and confer, the attorney for the receiver and the attorneys for, I think, Reichman and Kathy Griffin, and try to figure out some process to do that. I don't know if they've done that, but on the 18th, we will find out. And basically, the argument that the other sides were making is we're entitled to a trial, et cetera. And if you make it basically that our shares are subject to being canceled without a full trial that deprives of due process. That's kind of the dispute. But they're frozen, so they can't really dispose of them. And I think originally when we discussed the deal going forward, we needed the shares, or at least it was referenced, the shares had to be all returned. But I think now the issue was, I think my understanding is that as long as they were frozen, that would not be an impediment to closing the deal. So I think the fact that we got the freeze was really important. The fact that we'll continue to get shares back is fine. And I will get back to the share issue in a second. My understanding is, and again, I'm not firsthand involved in this, so I don't have firsthand knowledge. This is just based upon my information and understanding and speculation. Obviously, this is not legal advice. Took me like 11 minutes to say it's not legal advice. But everything prior to this was not legal advice. Neither is this. So what's going on is there are ongoing negotiations between AIversity and the receiver. I think they're making really good progress. I think they're hopeful that an agreement will be reached very soon, a final agreement. There was a preliminary agreement. The court approved it. Then the parties, that's the way it goes. So you have like a preliminary agreement, but then you have to detail all the kind of provisions and all the terms. That's what they've been doing. I think they're in the process. I think they're nearly, I don't know because I'm not involved, but I think they are near the end stages. So if the audit's completed, I think we're not far from having a negotiated deal also. I don't have firsthand knowledge, and I can't tell you exactly when, but for me, it appears we are nearby. Could it happen before the 18th? I guess it could, but that would be very soon. But I wouldn't be surprised if there is a deal, and obviously there's no guarantee of a deal, but I wouldn't be surprised if there's not a final agreement sometime shortly thereafter. And again, no guarantees of that. But in general, the read I'm getting is that there is ongoing progress being made, and this is a deal that looks like it's going forward. No guarantees. Anything could happen. Parties could change. Perhaps all things could happen. But we're going in a positive direction, and I think we're making really good progress towards an end and maybe a completion. So that's that, and I think that's great. But it'd be greater if I could say that they have a deal signed, sealed, delivered, the court signed off, and we're done, and we're relisted. But we haven't got to that point. And again, anything can happen in the meantime. I don't think, let me just leave it at that. Anything can happen in the meantime, so nothing's guaranteed. But from where we started, again, we're making progress. We're making steady progress, considering that we just kind of think about it where we started. We wanted to get rid of, really, this is what it came down to. We, being us, we had two goals. One was get rid of existing management. Two, find a deal, get something in there so that the company could prosper and all the shareholders could prosper. Obviously, we got rid of management, and now we are, I think, close to having a deal done. And I think if we can get that, then we are rolling. No guarantees, of course, but if we can get there, you all should be all proud of yourselves that we would, and we're not there. So again, I'm not predicting the victory, but we've really pushed the ball, and it's hard. It really is hard. You can imagine, just if you think about what's gone on here, the amount of various people that were involved to press. So it's hard. So you should all be proud. And if we get to the finish line, you really should take a bow that you hung out, you supported the cause, and perhaps, and again, I don't want to prejudge it, but if we can get this done, perhaps it can be a model for others to use. It's very complicated. So, but anyway, I wanted to thank you all and appreciate the support, and want you to all keep the pressure on. Point number 4. So as to those shares, so the shares are frozen, and what's going to happen to those frozen shares? So I told you about, one part is they're trying to work out some kind of mechanism to deal with the disputed shares of dubious consideration in nature. The other thing is, in the meantime, what they're deciding, and I think they're leaning to, is engaging, and I think I've referenced this, but I think it's more, at least my understanding is, of more certainty, a mediation of their shares. So what they want is, and I think this would be referring to the Reichmans. Again, I don't know that for a fact. I don't have any firsthand knowledge, just my understanding. But my understanding is the Reichmans want to have a mediation. My understanding also is that there was some type, and I don't know what the numbers were, but there was some type of demand, at least one, from the receiver to the Reichman camp to return X number of shares. I don't know what the number is. The Reichman camp did not respond with I think, an appropriate response, or was late, or something like that. But I guess the appearance, or my understanding was that their response wasn't sufficient, or may not have been characterized even as being in good faith. That led them to the mediation. So what's mediation? Mediation, just an explanation, because we talk about mediation and arbitration. Arbitration is where you actually have somebody who's a decision maker that will act like a judge and make a decision about a case or a dispute or something like that. Mediation, on the other hand, is where you have a third party. It could be a judge, but they're basically trying to get the parties to negotiate and to work out their own resolution. A skilled mediator can certainly help in bringing the parties together, but sometimes not. And there's no requirement that a result be reached. So my concern, and I've expressed this to the Receivers Council, my concern is that Reichman, who hasn't to this point in time indicated a willingness to return his shares, if they're not willing to say, we're going to at least guarantee we'll return X number of shares, I think there's no reason to mediate. And I would, if I were in that position, knowing what I know, and I don't know what they know, so, just being honest about it, Receivers Council's in there, they have a lot more knowledge about what's going on in dealings with all these parties than I, who am from the outside with information, but from the outside. So my statement is based upon what I know, which might be different, but I would not. I would mediate. I would, if it were I would take David Reichman's deposition, and I'd force him to testify under penalty of perjury. And if he elected not to, then I would take that. And my understanding is that under Nevada law, if somebody refuses to testify, and if they assert some type of a privilege based upon, concern about prosecution or something like that, that you then can't defend yourself in an action. And I don't see any reason to give, unless, again, there might be some reason. I'm open about it. There may be some reason for doing it, but I wouldn't go that route. I would, if they weren't willing to negotiate in good faith right away, I would I'd go in, make open discovery, and I would take Reichman's deposition and force him to take a position, force him to take the risk, and force him to expose everybody else. And anybody else, and I put this out there, I put this out there occasionally, any other defendant who wants to help, and I'm sure they contact me, but they certainly can contact the Receivers Council, and I'm sure if they have really useful information and they're an insider, although I'm not speaking for the Receivers Council, but I'm sure they'd be willing to listen and probably give a very good deal to somebody in that position. And what's going to happen, I believe, to all these people, and sometimes, people get pressed and they're not thinking right. Because just imagine, to this point in time, if you believe the receiver's reports, then all these defendants went along with all this stuff, if you believe his reports. So people can be, people do funny things and can be taken along interesting paths. So even today, when any logical person, based upon the receiver's report and what might arise out of that, would want to keep it quiet, but for some reason they're not acting in that way. And perhaps it's because they believe they haven't done anything wrong. I think it's kind of the receiver's report speaks for itself. So the bottom line is I wouldn't negotiate with them. I would just press them. And I'd basically say, F them, F you. If you want, if you want to return the shares and all the money, then fine. If not, then let's just go. Let's go. Take your deposition. We'll go to trial. We'll take your shares and we'll take all your money. And I would do it with a smile on my face. If they're willing to participate in good faith and they agree to, and I'm just making up numbers. If Reichman has 50 million shares, David Reichman has 50 million shares, and he says, I'll participate in a mediation, and no matter what, I'll guarantee you to return 25 million shares as a start, just as a starting point, then okay, that's at least a sign of good faith. But if he's going in with nothing and he's just buying time, wasting money, I have no interest in that. And if it were me, knowing what I know, I would just say, whatever, expletive deleted. But hopefully we will know more on the 28th about that too, because it'll probably come up in relation to the process about how the disputed shares will be treated. So that's on the 18th also. I expect to have some information about that too, although not guaranteed. Last but not least, so Alpine is so Alpine is was the prime broker for GTII, who had a short position as determined by the DTCCCC, and they have been in trouble. They got an expulsion, expedited expulsion. They went to the Supreme Court. They lost in the Supreme Court. They tried to get the expedited expulsion proceeding heard before the Supreme Court. I said that didn't make sense to me. It wasn't the right case. But they are now on appeal of the expulsion. So they had an expulsion that was affirmed 3 years after the original order by FINRA. It just went to the SEC. There was a brief due. I think they got an extension. I think people were arguing about the extension of their time to file a brief. I'm sure it's tactical, but just from being realistic, in that system where FINRA is taking action, disciplinary action against its own member, and where the Supreme Court's been asked to intervene, I think they will be really careful, and they will give, and I think it's inappropriate, by the way, but I think from a practical standpoint, they will give Alpine as much time as they need to file a brief. So to put it in proper perspective, so Alpine on the expulsion was expelled. There was an order. Then that was confirmed, and now it's before the SEC. Their briefs being filed, and the SEC has to sign off on their expulsion to be final, let's say. Although theoretically they could still appeal to the federal court. But what I expect at some point in time is Alpine will appeal that, whether that's the SEC's ruling or before that, to the Supreme Court on this matter, because the Supreme Court last year in Jarkessi said that if there's basically a common law claim involving money damages, that you have a right to a jury trial before the SEC. Now, even though this is a review, so this is where it comes down to be a little tricky. This is a review by the SEC, but it's de novo. So that means that they look at it like from scratch. They don't consider the decision of the other parties. But sometimes you could do de novo where you actually will put on evidence or additional evidence. And in this case, I think what happened was and again, I wasn't there, but let's say in 2020 when this proceeding happened, there was Alpine, I believe, Alpine did ask for Alpine did ask for what did they ask for? They asked for something. No, Alpine asked for certain evidence to be put in, and the trier of fact denied it. So if I were Alpine, and I have no love lost for Alpine, I hope the federal government steps in, puts them in receivership, puts them out of business because they're still operating. But, for Alpine, I think that gives them a position. They could argue that they have a Seventh Amendment right to a jury trial still because it's a case involving money damages. And they could do that theoretically before the case goes to the SEC, or they could do it afterwards. The afterwards, I think, would be more of a delay because I don't know how long it's going to take the SEC to do it, get a decision. They might believe, there's no hurry. We could just wait till the SEC issues a decision. We'll ask for a jury trial during the case. They'll say no. And then we have a case to take to the Supreme Court, depending on how it turns out. Or they could take the other act, the way they could do it. I think they should do this way, to be honest, is they should file it before the SEC, citing Gtii, because that they can't get a jury trial. But the issue will be, since Gtii was before the SEC on money, this is a review. Is that the same thing? And then the other issue is if they had evidence that was denied and they asked the SEC, who's reviewing it, to enter that evidence, then it becomes more like a regular trial before the SEC. And Gtii, which was decided last year, which said basically the SEC has to give a jury trial in front of a federal judge when there's a common law claim involving money damages. I think Gtii would be involved. So what would happen if that was the case? Then perhaps Alpine, who's making this argument that FINRA shouldn't exist or shouldn't have all of these kinds of powers, would have a better position, I think, to go to the Supreme Court and perhaps get FINRA eliminated from their position. Because if their ability to impose sanctions and punishment on their own members is blocked by the Supreme Court, is saying that they're not properly entitled to do that based upon constitutional grounds, non-delegation, separation of powers, etc., then they would cease to really have any function to exist. And I would think the SEC would be able to cut bait from them at that point in time. Now, the SEC has its own problems. To this point in time, I've not been impressed by them, but you never know. One last thing, FINRA, about a week ago, instituted new rules that were designed to give more discretion to parties that were sanctioned. In other words, if you're sanctioned by FINRA, it give you more leeway to either avoid them, to stretch out payments, etc. And it also said, using Alpine, it passed a new rule that said it's not final until the SEC signs off, which for Alpine was when they first got expelled, that was the final order. And when that was affirmed, that was still a final order. And even though the SEC is going to review it, it's still a final order. According to the new rules, it wouldn't have been a final order until the SEC signed off. And they think the reason, and I mentioned this before, the reason why the FINRA justified that is they said, even if they don't enforce that order, like they did, we'll use Alpine for an example. So Alpine was shut down. They were claimed to have misappropriated like 50 million plus in client fees, and other things. What FINRA did is they entered an order prohibiting them from engaging in that conduct. It was a cease and desist order. And the reason the expedited expulsion proceeding started was because they violated that order, the order that was supposed to protect investors who might be harmed. They only did it 35,000 times. So that order really didn't protect investors, but actually in the language of the rule change, like 2 weeks ago, the FINRA has the audacity, the huevos rancheros, to claim that those kind of conditions will prevent the party who's accused from committing them. So just think how illogical that is. They claim that if they told Alpine not to do something, they wouldn't do it because they get in trouble. And what actually happened was they told Alpine not to do something, and Alpine only violated that order 35,000 times, according to FINRA. So the rule change is absurd and ridiculous. It only serves to further protect members, not the public, not retail, no reason for the existence of FINRA. And again, if we can use Alpine as the vehicle to get rid of FINRA and then use the courts to get rid of Alpine, that's the way we should go. And I just throw that as in a tagline because that's in addition. And again, I look at this situation as incredible as what you got going on. You have like apparently bad actors shorting the stock. You have management apparently engaged in crazy misconduct. And then you have regulators. I have no idea what they're doing other than perhaps taking vacations in Hawaii or the Caymans or elsewhere and not acting after basically recognizing that investors were at risk. Really absurd, an absurd trio, the trifecta. But we're getting there. We're making progress. So that's all I got to say today. If I find anything new about either the audit or disputed shares, negotiations, mediation versus litigation, or Alpine, I will certainly let you know before the 18th. Otherwise, obviously, I'll do a live stream after the court hearing on the 18th, depending on what time it ends, and we'll follow up and find out what's going on there. To all of you who were out there who hung out here today, I appreciate it. Thanks as always. Please share, comment, like, get your friends, enemies too. Let them know. I appreciate it all. If you have comments after later on that you want me to look at and perhaps answer, please put them in the comment section. Otherwise, appreciate you all. Hope you're all well. Be safe and have a great day. And we're getting there. And be well.